According to the official files at the Federal Bureau of Investigation, in the Roaring '20s, Al Capone ruled an empire of crime in the windy city of Chicago, which included gambling, prostitution, bootlegging, bribery, narcotics, trafficking, robbery, protection rackets, and murder. And it seemed that law enforcement could not touch him. He was untouchable. And even though it was widely rumored that Capone had ordered the brutal murders of 7 gangland rivals in the infamous St. Valentine's Day Massacre, the FBI could not become involved because of a lack of jurisdiction. The killings, although brutal and cruel, were not a federal offense. According to the official files of the FBI, it was not until the year 1929, the year of the infamous stock market crash, attributed to bringing the Great Depression, that federal investigators got their first break. On February 27, 1929, Capone was subpoenaed at his winter home near Miami, Florida, to appear as a witness before a federal grand jury in Chicago on March 12th for a case involving a violation of prohibition laws. Capone said he couldn't make it. His excuse? He claimed he'd been laid up with a bronchopneumonia infection for 6 weeks and was in no shape to travel. As bizarre as it may seem, that a gangland-style murder did not compel the FBI to take action. It was this seemingly minor event, a person blowing off a subpoena from a court, that prompted the U.S. attorneys to commence an investigation to determine whether Capone was on the level and a stand-up guy. Federal agents were dispatched to Florida and quickly found that Capone's story didn't hold any water. When he was supposedly bedridden, Capone was out and about, going to the racetracks, taking trips to the Bahamas, even being questioned by local prosecutors. And by all accounts, his health was just fine. And on March 27th, 1929, just a month later, the Chicago Don Al Capone was cited for contempt of court in Chicago and arrested in Florida. He was released on bond, but from there on, it was downhill for the notorious gangster. Less than 2 months later, Capone was arrested in Philadelphia by local police for carrying concealed weapons and was sent to jail for a year. When he was released in 1931, Capone was tried and convicted for the original contempt of court charge. A federal judge sentenced him to 6 months in prison. In the meantime, federal Treasury agents had been gathering evidence that Capone had failed to pay his income taxes. Capone was convicted and on October 24, 1931, was sentenced to 11 years in prison at Alcatraz Island. And when he was finally released from federal prison, Capone was too sick to carry on his life of crime. He died in 1947. In the end, it took a team of federal, state, and local authorities to end Capone's reign as an underworld boss. Precisely the kind of partnerships that are needed today, as well as to defeat dangerous criminals and terrorists. It was a process that consumed just a month to set in motion after federal investigators became involved. And it all began not because of a gangland-style execution, or what looks a lot like a crime to most, involving some gangster rivals, but something as simple as failing to respond to a subpoena. Under 18 U.S.C. Section 1961, Paragraph 5, the federal statute governing civil actions brought under the Racketeering, Influence, and Corrupt Organizations Act, or RICO, a pattern of racketeering activity requires at least 2 acts of racketeering activity within a span of 10 years, separating each commission. Under 18 U.S.C. Section 1961, Paragraph 1, subparagraph B, racketeering activities include violation of the criminal provisions under 18 U.S.C. Section 1512, paragraph B, pertaining to tampering with a witness in obstruction of justice. Under 18 U.S.C. Section 1512, paragraph B, subparagraph 2, subparagraph C, the federal criminal provision regarding obstruction of justice, it is unlawful to be absent from an official proceeding to which such person has been summoned by legal process, which may include a service of summons for a subpoena ducis tecum, or summons to produce documents, a subpoena ad testificandum, or a summons to appear in court as a witness, or a summons to appear as a defendant in pending litigation, criminal or civil. And there is not any genuine issue of material fact as to whether former Virginia Congressman Jim Moran, the famed fighter for progressive causes, and infamously wily nolo contendere pleader who escaped imprisonment on a charge of vote peddling, a violation of VA Code 30-355, the state conflict of interest law in 1984, 5 years after he was elected to the Alexandria City Council, did, in fact, fail, in contravention thereof, to respond to a subpoena issued in the matter of the Carlton Condominium Unit Owners Association v. Webb, case number GV 1700-5335-00 in the Arlington General District Court. Similarly, there is no genuine issue of material fact as to whether or not the same Jim Moran did fail to respond to a summons to appear as a defendant in Webb v. Kane, case number CL 18-3628, in the Circuit Court for the County of Arlington, and presently record number 0638-19-4 in the Virginia Court of Appeals. And thus the clock begins ticking on the notorious political don, Jim Moran, the Intimidator. This advertisement was authorized by Mike Webb.